you may go on to AB 329, bail.
Thank you. Again, Mr. Chair, colleagues, and staff, and thank you for the aye votes on the last bill. I really appreciate it. AB 329 is a bill to fundamentally reform California's pre-trial justice system on behalf of thousands of Californians who are held in jail pre-trial every year simply because they are poor. The money bail system penalizes poverty, setting a price on a person's access to pretrial release based on the size of their wallet, not the size of their risk. On any given day in California, 63%, or roughly 46,000 people in the state's jails are awaiting trial or sentencing, and 97% of them who make bail use a bail agent to secure their release. This means that thousands of Californians accused of crimes end up paying a fee to stay out of jail before ever being found guilty by a judge or by a jury. It is a broken system that has not made us safer or lowered the instances of failures to appear in court. In my view, it is unfair, unjust, and unsafe. Last April, in an effort to reduce overcrowding in jails and potential COVID-19 outbreaks, the Judicial Council enacted an emergency zero bail order that demonstrates a viable alternative to keeping people in jail pre-trial. After the Judicial Council discontinued their emergency bail schedule, 31 counties covering 80% of Californians enacted their own emergency zero bail schedules. AB 329 builds on the emergency bail schedule set by the Judicial Council to build a more effective and a more just system. The bill reforms money bail not by eliminating it, but rather setting bail at $0 for misdemeanor and nonviolent felony charges. For all other crimes, the new legislation will require the California Judicial Council to create a uniform bail schedule with standard bail amounts statewide, so there will be certainty and consistency among our 58 counties. AB 329 would also require people who pay bail to receive a refund minus a small surcharge that is retained by the bail bond company if the charges are never brought, if the charges against them are dropped, or if they attend all mandatory court appearances, meaning they appear at all times when they are required. Currently, bail companies have built an immensely profitable industry through the current system, collecting high fees, usually on average 10% of the full bail amount. The average bail amount in California is $50,000, 10% is $5,000, while rarely forfeiting bonds posted to the court. Regardless of whether a case is dismissed or if charges are not ultimately filed or if they're dropped, the bail company keeps its premium. Individuals pay these premiums because the alternative is worse. Being stuck in jail can mean losing a job, losing a car, losing a home, losing a family member if they have custody of a small child and they're the only parent who can do that. The jailhouse door should not swing open and close based on how much money someone has. There is no disputing the present system wrongly treats people who are rich and guilty better than those who are poor and innocent. In my view, the status quo is indefensible, and we cannot defend the indefensible. It disproportionately impacts low-income Californians and communities of color. Money bail epitomizes unequal justice, and we must continue our fight for equal justice under the law. I respectfully ask for an aye vote on AB 329 so we can create a future for California that embraces social justice and economic justice, a future that eliminates blatant discrimination against the poor and makes us safer. Thank you. I have as a witness Esteban Nunez, representing the Anti-Recidivism Coalition, a sponsor of this bill. Thank you, colleagues.
Is Mr. Nunez on the phone? And
yes, sir.
And you have 5 minutes.
Okay.
You don't have to use it all, but
and members of the. Okay.
Okay.
I'll be mindful of the time. I won't use all the 5 minutes. But as Assemblymember Bonta said, my name is Esteban Nunez. I am the Director of Advocacy and Community Organizing with the Anti-Recidivism Coalition, also known as ARC. ARC works to end mass incarceration in California. To ensure our communities are safe, healthy, and whole, ARC empowers formerly and currently incarcerated people to thrive by providing a support network, comprehensive reentry services, and opportunities to advocate for policy change. Through our grassroots policy advocacy, we are dedicated to transforming the criminal justice system so that it is more just and equitable for all people. ARC has worked tirelessly to reform California's pretrial system for nearly 5 years now because we believe in equity, fairness, accountability, and economic justice. I want to ground us in a story of an ARC member who sadly is unable to be with us today. Right before COVID ran rampant and California implemented the zero bail schedule for people being charged with lower level offenses, an ARC member who had been internally struggling with substance abuse issues was arrested and charged with vandalism. His bail was set well beyond the means of what he could afford, and truth be told, this young man was in dire need of help and supportive services, not county jail. A week later, he was murdered in county jail. What he really needed was wraparound services and community support like that of ARC. Oftentimes, low-level offenses are crimes of desperation, an outcry, if you will, not one that signals a future of life of crime, but one that signals that their very basic needs are not being met. County jail can not only be traumatizing, but it exacerbates underlying traumas and conditions. It's not a place of healing, rehabilitation, or maturation. County jail is a place where you are quickly stripped of your dignity and confidence. It's a natural depressant riddled with despair and fear. Fear of what lies ahead. Fear if your employer would understand why you haven't showed up for work. Fear if your children will end up in the system because you are in jail. Fear that you may be forced into a plea bargain because you know our system has stacked the odds against you, or worse, fear of death. The zero bail order was temporary, and went into effect from April to June of 2020. Under this order, we did see a significant reduction in county jail populations across California, and we saw no real spike in crimes for those offenses which were zero bail eligible. BSBC data shows a statewide decrease of 30% in county jail populations between February and May of 2020. Although California's bail schedule was lifted in June 2020, as Assemblymember Bonta said, 31 counties, which account for close to 80% of California's population, kept some form of zero bail schedule in place. Why would they do that if they knew there were inadvertent impacts of seeing spikes in crime? Well, there weren't. A report published last October by the Public Policy Institute of California proved that there was no major spike in crime for those offenses which are zero bail eligible. Furthermore, an analysis by KTVU, which analyzed 5 Bay Area counties, Alameda, San Francisco, Contra Costa, San Mateo, and Santa Clara, found that in the time California had instituted a zero bail policy, somewhere between 3 to 12% of those individuals who were allowed to bail out for free were rearrested during roughly a 1 to 2 month period, which is significantly lower than California's recidivism rate and even conviction rate. The Pretrial Justice Institute reports that the cost of supervising a person in the community while pending a trial is 10% that of the cost of keeping that person in jail. With data showing that the vast majority of people released pretrial do not reoffend and that very little is needed to ensure that they show up to court on time, these costs, both human and financial, are just unjustifiable. It is for these reasons that we, the Anti-Recidivism Coalition, along with our co-sponsors and supporters, urge you to vote in support of AB 329. Thank you.
Thank you. Okay, are there any witnesses in the room that's in support? Any witness in the video conferencing room in support? Any witnesses online that are in support? AT&T, you may allow them in.
If you are in support of AB 329, please press 1, then 0. And we are going to the line of 108. That's 108. Please go ahead.
Good afternoon, Mr. Chair. Christopher Sanchez with Western Center on Law and Poverty. We're proud to be a co-sponsor of this bill.
Thank you.
And our next support comes from the line of 109. Please go ahead. Your line is open.
Hello, Chair, members of the committee. This is Janice O'Malley with the California Labor Federation in support.
Thank you.
And the next support comes from the line of 78. Please go ahead.
Good afternoon. This is Rebecca Gonzalez with the National Association of Social Workers California chapter in support.
Thank you.
And line number 66, your line is now open.
Tom Hoffman, Californians for Safety and Justice, in strong support.
Thank you.
And our next line is number 90. Please go ahead. Your line is open.
Tiffany White with SEIU California in support. Thank you.
Thank you.
And our next line in support is line number 69. Your line is now open.
Danica Rodarmel on behalf of the San Francisco Public Defender's Office in support.
Thank you.
And our next line is line number 60. 60, please go ahead.
Anthony DiMartino with Californians for Safety and Justice, proud co-sponsor of AB 329, and also on behalf of Next Gen California and Smart Justice California in support. Thank you.
And our next support line is 129. Please go ahead.
Martha George on behalf of the California Public Defenders Association.
Thank you.
And our next line is 100. That's 100. Please go ahead.
Yes, Ignacio Hernandez on behalf of the California Attorney for Criminal Justice. We're actually a tweener position. We support the overall direction. Look forward to continuing our discussion with the author's office about some suggested changes to the language of the bill.
Thank you.
And our next line is 152. That's line number 152.
Ruby Gradias, outside organizer for Initiate Justice, in support.
Thank you. Our next line is 147. Please go ahead. Line number 147, your line is now open. Okay, our next line is 161. It's line number 161.
Kendra Zoller on behalf of Insurance Commissioner Ricardo Lara and the Department of Insurance in strong support.
Thank you.
And our next line is 132. Line number 132.
Good afternoon, Mr. Chair and members. Rosanna Carvacho Elliott on behalf of the City of Alameda in support. Thank you.
Thank you.
And line number 75. That's line number 75.
Good afternoon. This is Andrew Moose Fisher with the League of Women Voters of California in strong support.
Thank you.
And we have line number 167. That's line number 167.
Yes, this is Maddie Hayek from the California Civil Liberties Advocacy, also in strong support of AB 329.
Thank you.
And once again, if you are in support of AB 329, please press 1 and then 0. And we have line number 171.
Good afternoon. This is Jim Lindberg on behalf of the Friends Committee on Legislation of California in support. Thank you.
Thank you.
And our last line here we have in queue is 147. Line number 147.
Mary Moreno, California resident, in full support of SB 329.
Okay, one moment here. And that's in support of AB 329. That's 1 and then 0. Okay, we are not showing any in queue at this time, Mr. Chair.
All right. Thank you. I have 2 witnesses in opposition, Nina Salerno Besselman, Crime Victims United, and Larry Morse, the second California District Attorney Association. Ms. Besselman, you can go first.
Yeah, Assemblyman, excuse me, I was coughing. I was going to defer to Larry to go first, if that's okay.
Whatever order you want, but you still only have 5
minutes. And I apologize,
5 minutes.
I was coughing just a second there.
Okay, no problem. So, Mr. Morris, always a pleasure to hear from you. You begin first. Mr. Morris? He may be having technical problem. AT&T, do you know if he's having technical problems?
I don't know if there's a way to tell.
Let's double check. We don't want to leave him out. Is there a way we can double check to see where he is?
I'm taking a look here. Hold on one moment. Okay, so I don't see him in the room here online. I don't see his line at all.
At all.
I'm not sure if he dropped.
Ms. Besselman, I guess you'll have to go first, and hopefully Mr. Morris
I guess I'm going first.
can well, hopefully he finds the number in the next couple of minutes.
Okay. Honorable Chair and members, I want to thank you for the opportunity to speak on AB 329. Crime Victims United, although respecting the members who have brought this forward, does respectively oppose the bill for the following reasons. Crime Victims United is an ardent supporter of thoughtful and well-vetted criminal justice reform. However, AB 329 is not that. It is not well thought out, and it impacts the people of the state of California in many ways, and in particular, it impacts the victims of crime. There is no provision in this bill to provide for the voice of the victim, and specifically in the California Constitution, Article 28, it provides that a victim can be heard at a bail sentencing so that their safety in particular can be considered when somebody is released. There's nothing in this bill that provides that. Secondly, what gives me concern and gives the victims of crime concern on AB 329 is the fact that this is targeting what we call low-level offenders. Well, included in that are domestic violence offenders, hate crime offenders, child abuse offenders, and human trafficking. And these victims are a particularly vulnerable population that will be affected by people being released without any accountability. And especially when we look at domestic abusers, I think the members of this commission know very well that that is the most dangerous time for a victim, is when he or she are trying to escape their abuser. And to have somebody released without accountability could place them in great violence. And again, not being able to be heard before the release is critical to the safety and the public safety. I understand the concern about incarcerating people and paying to get out. I have respect for that. We are willing to work towards that. In fact, we are working with Assemblyman Cooper, who has a bill that addresses those issues that I believe is much more vetted and well thought out in the realm of public safety. And I would urge the members to consider that and consider that we need to find a remedy that not only addresses the issue that this bill is trying to address, but also protects the rights of the victims. And lastly, I would urge you to also listen to your constituent and voters. Just in November, we had an initiative that tried to basically effectively wipe away bail in California. And I know that there's issues that there was arguments, well, that was based on the system. Well, from the victim perspective, who was a strong against that initiative, came out strong against the initiative, many crime victims did, again, for these same reasons that I'm bringing forth, that there was no protections for our constitutional rights, no balance in the system. I agree that the bail schedule needs to be addressed. I don't think there's any crime victim that doesn't agree that the bail schedule needs to be addressed and that people should not be incarcerated just simply because they don't have the monetary means. But that does not mean that we can just let them out without consideration of the victim's safety. I would respectfully urge a no vote on this. Again, I would strongly ask the members to look at Assemblyman Cooper's bill, AB 38, as an alternative. Thank you.
Thank you. And it's Ms. Salerno Besselman?
Salerno.
Salerno.
Yes. And thank you for your time. And again, I'm sorry, my voice is kind of scratchy.
So is mine. So, Mr. Morris, if you're still out there, the number, if you're having problems getting in, is 916-319-3744. 916-319-3744. They're showing you there, but we're not getting. You're talking to the staff right now. So hopefully, as we go through some of the Me Too's, that oppose the bill, maybe you can come in right after that. So the Me Too's that are in opposition of AB 329. AT&T operator.
And if Larry Morse is in the room or online, he can do *0, and we can get his name and find his line if he's in there. So that would be *0. He's already in there. We are looking for opposition of AB 329. Press 1, then 0. And we do have some queuing up here. Once again, that's AB 329, opposition.
Mr. Chairman and members, can you hear me?
This is Larry Morris. Larry.
Mr. Chairman, members, can you hear me?
Yes.
This is Larry Morris.
I can hear you, Larry. Can you hear us? Turn, are you in on your phone and your computer, or you need to turn it down? We're getting some feedback. Now we have nothing.
How about now, Mr.
All
Chairman?
right. There you go. You may begin.
How about now, Mr.
Yes, begin.
I'm sorry to be such a pain. Technology is wonderful. This is Larry Morris on behalf of the California District Attorneys Association. We are respectfully opposed to Senate Bill 262, which would require that bail in most criminal offenses be set at 0. As Assemblymember Bonta no doubt recalls from his appearance at a CDAA conference a few years ago on the bail reform bills that he and Senator Hertzberg were pursuing, California's elected DAs recognize and embrace the need for thoughtful bail reform. As Assemblymember Bonta knows, CDAA did not oppose those bills, nor did it oppose Proposition 25 last November. This year, CDA is supporting Chairman Joan Sawyer's bill, AB 1347, that would put an end to the unfair practice of charging yearly bail renewal premiums. We must, however, oppose AB 329 because, in our view, it does not adequately account for threats to public safety and would largely remove the discretion of a court to set bail as appropriate to the facts and circumstances of a given crime and the history of the person charged. CDA believes that as we continue to pursue Assemblyman Bonta's goal to create a fairer and more equitable bail system, we must be careful to balance protecting the rights of the accused with protecting public safety. Unfortunately, SB 262 requires the court to set bail at 0 for a wide range of criminal charges and circumstances that present an unacceptable risk to the community. For example, the court would be required to impose 0 bail on most hate crimes at a time when we are painfully aware of their increasing frequency and menace. 0 bail also would be required for such crimes as witness intimidation and felony possession of an assault weapon. The bill also draws arbitrary, confusing distinctions between alleged criminal conduct. For example, a person charged with misdemeanor domestic violence would be subject to bail. That same person, however, if charged with some types of felony elder abuse or child abuse, would be granted 0 bail. The implementation of a 0 bail schedule last year to mitigate the impact of COVID-19 exposure in local jails was specifically conditioned on the ability of the court to set bail when appropriate. Inexplicably, that language vesting discretion with judges is absent from this bill. There is nothing under current law that prevents a court from releasing an accused on his or her own recognizance or setting bail. And as a prosecutor for 27 years, I saw it happen regularly. Judges frequently exercise this prerogative to maintain or depart from scheduled bail after input from prosecutors and the defense. CDAA is supporting Assemblyman Cooper's AB 38 bail reform bill that would create a statewide bail schedule to be determined by a group of judges selected by the Judicial Council with representatives from the California Public Defenders Association, CDAA, and the California State Sheriff's Association. The statewide bail schedule would be revised annually and would include public input. This approach seemed better tailored to achieving uniformity and fairness while protecting the public. A person charged with a crime should never remain in custody solely because he or she is poor. CDA supports the continued efforts to reform our bail system. However, we do not believe AB 329 is the best vehicle for achieving that goal and respectfully.
Thank you, Mr. Morris. Now, AT&T, are there any other witnesses in opposition to AB 329?
Yep. If you're in opposition of AB 329, please press 1 then 0. And we do have line 136. Please go ahead.
Yes, thank you. Good afternoon, Mr. Chairman and members. Paul Bauer on behalf of All Pro Bail Bond in opposition to AB 329. Thank you.
And our next line is 170. Please go ahead.
Good afternoon. My name is Sydney Hoff with Resolute. On behalf of the California Bail Agents Association, we're opposed over the constitutionality of this bill. Thank you.
Thank you.
And the next line is 87. Your line is now open.
Mr. Chair, members of the committee, this is Jeff Clayton, Executive Director of the American Bail Coalition, here today in opposition to Assembly Bill 329. Thank you.
Thank you.
And our next line is 151. Please go ahead.
Good afternoon, Mr. Chair and members. Corey Salzillo on behalf of the California State Sheriff's Association, respectfully in opposition to AB 329. Thank you.
Thank you.
And our next line is 176. Please go ahead.
Good afternoon, Mr. Chair, members of the committee. Kathy Lynch, representing the Golden State Bail Agents Association, in strong opposition to this bill. Thank you.
Thank you.
And our final opposition in the queue is 163. Please go ahead.
Good afternoon, Chair and members. Jonathan Feldman with the California Police Chiefs Association, opposed to the bill in print. Thank you.
Thank you. Are there any?
And we do not have any more oppositions in chair.
Thank you. Are there any questions from committee members? Mr. Lackey first, and then Mr.
Yes.
Quirk.
Thank you. Assemblymember Bonta, why is there no risk assessment element in this particular bill?
Thank you for your question, Mr. Lackey. This is a different approach than SB 10, entirely different. SB 10 and Prop 25 propose to completely eliminate money bail and replace it with what you're referring to, a risk assessment tool, as well as some judicial discretion in setting bail. This is building off something that we've had in place during the pandemic, as well as approaches that have occurred successfully in other jurisdictions like New York, New Jersey, Kentucky, where there was zero bail or a cite and release that didn't rely on bail, which led to many more people being safely released. Crime rates either went down or held steady. Appearance rates held strong. Reoffense rates didn't move. So we think it's an approach that can lead to many more people being safely and fairly released without threatening public safety. So it's just a different approach, I guess, is the short answer to your question, and is very different than SB 10. Money bail continues to exist with this proposal today with AB 329, but it does have components of zero bail, refundability, consideration of the ability to pay as set forth in the bill.
Okay, well, regrettably, I will not be able to support this bill as it stands currently. I also believe it's in direct contrast to the express will of the people by Proposition 25 in the last election. So that'll conclude my remarks.
Thank you. Mr. Quirk.
Yes, well, I will be supporting the bill today, but I do think it needs some work. And in listening to the opposition from the district attorneys, the fact that I do think that it would be good to allow judges some discretion. There may be people who've committed some of these less violent crimes who they feel need to pay bail, or perhaps they have a history of not showing up. Whatever it is, I do think we need that discretion if it's not in the bill. Second, I am concerned that the people who do have to pay bail may not have recourse to bail's bondsman. And the reason for that is since you require that the money essentially be given, 95% of it be given back, I don't think anybody will be in the bail bond business. And unless we set bail at a much lower amount, which would be a good solution, maybe 10% of what that typically is today, 5,000 instead of 50, that's probably enough to get people to show up. So if we were to reset the system, I'd be in favor of just bringing everything down 90%. I think that would be a better approach for the people that you do need to keep in jail. And again, a judge can always say, we will not allow bail in this case. So think about those things and no good bill goes unchanged, as you know. So just think about those things. Thank you very much, Mr. Bonta.
Thank you, Member Quirk.
Rebecca Bauer-Cahan has a question. Did you want to answer?
I did. It might be helpful for others who are asking questions along similar lines, but just wanted to thank Assemblymember Quirk for his always thoughtful input. I do want to reiterate that we are talking about a population that is innocent until proven guilty. They have not been convicted of anything at this stage in the criminal proceedings. And we believe that nothing in this bill conflicts with Article 1, Section 28 of the Constitution, which does give judges, to Mr. Quirk's point, discretion to detain pretrial when absolutely necessary. So if that is not clear to the opposition, we will seek to make that clear. And we do have a component in the bill which seeks to have the Judicial Council set a uniform bail schedule. Perhaps it will be 90% less than the current bail numbers. I think they will certainly take into consideration the fact that we are the highest bail schedules in the nation when setting that. And we do have a component in the bill which will await the guidance of the Humphreys case, which should be coming down in the next couple of weeks, which proposes to allow for the consideration of the ability to pay bail by individuals facing bail.
Thank you.
Thank you. Ms. Bauer-Cahan.
Thank you, Mr. Chair. I think this is an incredibly important effort and conversation, and I was pleased to hear that everyone, the opposition included, agrees that our current system where one remains incarcerated merely because they can't pay and they are poor is a broken system, and one that desperately needs to be fixed, because the question before any court when deciding who should be held when innocent, because we're talking pretrial, should be who is a risk to our community, not who can pay. And the fact that in my community we have someone who was let out who was at risk because he had the means to pay for it, and that too is a problem, that we need to be holding those who pose a risk and allowing those who do not pose a risk to our community to be able to go out and to keep their job and keep the roof over their head. And we understand the implications of being incarcerated before your trial and before you've been found guilty, and that until that happens, one should be able, if they are not a risk to society, to maintain that those important aspects of their life. That being said, I share a lot of the concerns of the opposition and of my colleague that this bill's failure to provide any risk assessment or judicial discretion leaves us open to individuals who do pose a risk to our communities being let out. And I guess I do read it differently than you do. I don't believe it maintains the discretion held under the Constitution. I read the bill to require courts for those charged of these offenses to let them out on zero bail, and that's a concern of mine. So if you do clarify that, that's, I think, a good amendment that will hopefully be taken in the future. But I'm glad that there are several bills moving in this space. I'm glad we're having this conversation. I look forward to a bill that I think strikes that balance of ensuring that we're protecting our community and not incarcerating people for being indigent. But I can't at this point support it because I don't think it yet strikes the right balance in protecting our communities. Thank you.
Any other comments?
Appreciate the input.
Seeing none, you may close, Mr. Bonta.
Well, I just thank you for the active listening and the very helpful comments. This is the first policy committee in the first house. We will certainly take into consideration your advice, counsel, and insight as we seek to improve the bill. I appreciate it from all of my colleagues as we try to improve it. I don't know that there's a perfect system. My belief is that the current system is absolutely unacceptable. We do have wealthy people who could and would do harm to others who are paying their way out and posing a risk to the community. We have folks who are absolutely no risk who will come to all their hearings who simply can't be released because they don't have enough money because they're poor. That is wrong. We know we need to change it. How we change it is up for important debate. SB 10 was a proposal. It had some really important components to it. It had some that created controversy. This is another run at strengthening and making more fair the system. We think that while it's not perfect, it goes a long way towards being both safe and fair. You can and we must do both. They are not mutually exclusive. So we think this is a really important starting point. Appreciate your input today, and I respectfully ask for your aye vote.
And thank you, Mr. Bonta. I know this is very important not only to you but several members in the assembly. The comments from Salerno, Besselman, and Mr. Morse are well taken. Right now, it looks like this committee doesn't have all the information. I'm hearing of a Cooper bill that I probably should have known about. I'm just now hearing about it. The troubling part is setting up a commission of all law enforcement is probably a non-starter. So let's make sure. And I know having risk assessment, as you and I know, is probably a non-starter for the pro side. And I want this committee to ultimately, these members here that you're looking at now, to weigh in heavily on how this ultimately is. And as Mr. Quirk, so in his sage wisdom, said, no bill gets out of here untouched or unchanged. And so I would ask that we move this bill out knowing that it goes to appropriations, knowing that whatever other bills, if there's more than one, that will have to come our way. And we can, and which is our responsibility as a public safety committee, we can actually probably try to craft, I don't want to say a compromise, but craft something that we can all move forward with. Because at the end of the day, especially in my community, ending cash bail on poor people is extremely, extremely important. And what I'm hearing, and I may be wrong, what I'm hearing is everyone, especially here, agrees we should have some kind of just bail system, or whatever you want to call it, or zero bail, or risk assessment bail, or whatever, or judicial bail. I think it's our responsibility here to work with you and any others to kind of trying to craft that into one thing. So I'm asking all members, if you can, to move this out knowing that we have others coming in, but we also have a great responsibility to hopefully craft something that will not only get out of our house, but will get out of the other house, and that since it is an assembly bill, we can look at it and be very proud of it because we crafted the final solution. So that's what I'm asking for, and I vote. Call the roll.
No, do we have a motion?
Do we have a motion? Ms. Wicks moved it. Mr. Quirk, second.
On AB 329 by Assemblymember Bonta, the motion is due pass to the Appropriations Committee. Jones Sawyer.
Aye.
Jones Sawyer, aye. Lackey.
No.
Lackey, no. Bauer Cahan. Quirk.
Aye.
Quirk, aye. Santiago. Sayarto.
No.
Sayarto, no. Wicks.
Aye.
Wicks, aye. Lee.
Aye.
Lee, aye.
That measure's on call.
Measures on call. We need one more.
Thank you, Mr. Chair. Thank you, colleagues. Thank you.
All right.